that it for you, Counsel? Or?
No, Judge, I have one more. This is going to make my head explode.
Okay. Ram partner versus Fry. Well, let me just call all four because I think we got an issue. Mika Fry, Naja Brown, Going Robinson, and Raisha. You all just come up because I mean I'm going to have a similar on these. They can just line up down that side. All right, who do I have here? Your name. Morning. Going Robinson. So the one I'm missing is Fry. All right. So the last time we were here, we had a problem with these properties because these were filed. These are really Arbor One cases, right? And the part that I'm a bit confused about is so for filing in the name of Beal, then there was some indication sent out that Ram Partners is now the management company.
Right out of the gate, Judge Simpson is telling you this is not a routine landlord-tenant hearing. It's an administrative knot with legal landmines all over it. And when a judge starts openly saying, "I'm confused," that is not weakness. That's a warning shot to everyone in the room that the paperwork, the party names, and the procedural posture may already be a mess. What he's zeroing in on here is something deceptively simple, but legally huge. Who actually has the right to bring these eviction cases? That matters, because if the wrong entity files, or if the filing is tied to a larger set of litigation problems, the whole case can wobble before anyone even gets to unpaid rent. Now layer in the fact that the original filings appear tied to Arbor One, but the court is now hearing that Ram Partners is the management company. That's not a cosmetic change. In housing court, the identity of the plaintiff is everything. Who owns, who manages, who has authority, who is trying to collect. If those answers shift midstream, the judge has to stop and make sure nobody is trying to enforce rights they don't actually hold. And the tone here already tells you where this is going. This isn't just about balances, it's about whether these cases were built on a stable legal foundation in the first place. That's the kind of issue that can derail multiple cases at once.
That is what I understand as well, Judge. So we're going to have to file amended complaints.
Yes, but I don't know what I have amended complaint.
Oh, they've already filed them. Okay, I was told
Well,
filed.
they filed them.
Yeah, I'm actually here for Ram Partners. No, because it was under
Who
Beagle.
are you?
I'm the property manager for the property.
Okay.
I just found out
What's your name?
an hour ago. Jillian Bailey.
Okay. So here's going to be the problem in my mind because I've got to sort this out. The last time we were here, the balances were of such a level, at least on 3 out of the 4, if I'm recalling, that they covered a significant time period. Typically, that might be okay, except that these are really Arbor One cases. Arbor One has there's significant litigation in our circuit court as well as the federal court. And so I don't know, first of all, whether or not whether this management company or whether Arbor One can proceed on these. And that may be part of the problem. The other issue in that is that since some of the amounts were of the nature that they were, even if on X date they could proceed, I'm worried that the back balances were part of something else. And it worried me even more because a new management company came in, so they're going to be looking at the number that they would have. I get that. But they may or may not know that part of that number may have been dealt with or disposed of to the extent that they can proceed, may have been dealt with in the circuit court. I think my head just exploded. I think it just went just Friday.
That line right there, "I think my head just exploded," is funny on the surface, but legally, it's the most revealing moment in the hearing so far. Judge Simpson is basically translating a nightmare docket problem into plain English. Here's the core issue. If some of these back balances or tenant obligations were already touched, reduced, wiped out, escrowed, or otherwise addressed in circuit court litigation, then this housing court cannot just pretend it's starting from a clean slate. That would create a real risk of double counting debt, enforcing obligations that may no longer exist, or allowing a management company to pursue balances without understanding what happened in the larger Arbor 1 litigation. And that's why the judge keeps circling the same concern from different angles, not because he's lost, but because he's trying to prevent the court from stepping into a procedural trap. If RAM is looking only at a ledger and saying, here's what's owed, but that ledger doesn't reflect what another court may already have done with escrow, compliance failures, or rent disputes, then the numbers themselves become unreliable. And once the numbers are unreliable, the eviction theory becomes unreliable too.
Misery loves company, Judge.
All right. So that's where we are. I don't know what go ahead.
Judge, I was brought into this late yesterday afternoon. As you know, Ms. Holm has been handling this. She's on trial today. When I discussed this with her, she said that she's having difficulty accessing the circuit court ROA to get the actual documents that she needs to know whether or not this court has stayed. And I suggested, and I have not had the time because I was on trial yesterday, whether we should talk with the prosecutor and see whether or not they can tell us where their cases are. And so that's my hope, is to sometime next week sit down with Ms. Holm when we're both in the office together, get a strategy together, and maybe contact the prosecuting attorney to find out where their cases are, to tell you whether or not you can go forward on these. Because she has tried, and I know she's been working on this, trying to access the ROA for the circuit court unsuccessfully, to access whatever order there is that tells you essentially whether or not you have the right.
Whether or not these cases can go forward. I will tell you, and just to back up, because I don't know that I told Ms. Holden. After the last hearing, or maybe the one before that, I can't remember. Because there was some confusion on my part, I contacted the other side of that litigation, that being legal services, to try and determine whether or not these folks were well, I was really more focused on the units, because there were some units that didn't have COC, some did, and I don't know when all of that transpired. You want to say something, because you always do. Go ahead, no.
Stating that it was a property management. That's been nice. I moved in. I was moved from the buildings that were not under compliance, and I was moved into a building that also was not under compliance when I moved in. And I have the email stating that when I withdrew my rent and everything.
And now the hearing pivots from courtroom confusion to something much more concrete. The tenants start filling in the human side of what all this Arbor 1 versus RAM versus circuit court chaos actually looks like on the ground. This tenant is saying she was moved from one non-compliant building into another non-compliant building. That is not a throwaway detail. In landlord-tenant disputes, a certificate of compliance issue can be a major problem because it goes directly to habitability, legality of occupancy, and whether rent should have been charged at all during certain periods. So when she says she has emails, dates, and communication showing that the building lacked temporary certificates at the time she was moved in, she's not just venting, she's potentially giving the court a factual basis for why these balances may be disputed, or why some rent obligations may have been affected by the broader litigation. And notice how this plugs directly into the judge's earlier concern. He was worried that the numbers in these eviction files may not reflect the full legal history. The tenant's statement is basically confirming why that fear isn't theoretical.
Also, I just want to mention.
Well, what time period are you talking about?
This was December 3rd of 2025, and I have the email from the property manager stating that they did not have even temporary certificates at that time. So
in December 2025.
Yes, and then I continued to email from there. I shouldn't
Go ahead.
say email from that point on. I kind of got ignored, and then so reaching kind of before I came here to court, I made an agreement with Jessica Nice. She said I did not have to pay this balance to avoid the eviction process, and I do have emails and paperwork regarding that. So when I was supposed to leave, I was summoned to court.
Jessica with who? Jeff.
Works with Bill Properties.
Okay. Anything you want to tell me?
It's got a eviction on my record, so I can't go anywhere. So when I do apply, so I'm
You're trying to figure out what you can do if you want. I got you.
stressed out.
And
You're stressed out?
I'm 50 years old. I want to be on.
You're not 50. Don't even try.
I'm
All right. All right. All right. So first of all, quit stressing. Because you stress, then I stress, then things get bad. All right. Mr. Robinson, anything you want to tell me, sir?
I was told the same thing she was.
And
They gotta come back up. Now they want to.
okay. And so council, just so that because you weren't part of those other cases, I had about before the case got filed against Harbor One et al. The federal part of that came in. I still had up until sometime last month, initially starting 50 Harbor One cases. Those cases were working themselves through in some way, but then got stopped because of the circuit court matter. At some point, and again, I'm sort of unclear, the circuit court was not preventing this court from going forward on those cases. I was just reluctant because there were global agreements going.
This is a crucial clarification from Judge Simpson because he's separating legal impossibility from judicial caution, and those are not the same thing. He's basically saying there was a period where the circuit court may not have formally blocked this housing court from moving forward, but he personally hesitated because there were broader, global agreements and litigation issues unfolding around Arbor One properties. That matters a lot. It tells you the judge wasn't sitting on these cases for no reason. He was trying not to let one courtroom undercut what was being negotiated or resolved in another. Then the tenant's statements snap into focus. When they talk about buildings lacking compliance and rent issues tied to those conditions, Simpson immediately says it makes sense. That's not a ruling in their favor, but it is the judge signaling that their story fits the pattern he already knows from the larger Arbor One mess. And once he starts talking about escrow being returned to tenants, rent potentially being unchargeable, and prior Arbor One cases being dismissed, you can see why he refuses to just plow ahead with a simple pay or move framework. The underlying question has become, are these balances even real in the way management claims they are?
What these two are telling me makes sense. Okay, because there were buildings where the certificate of compliance was not there. And I can't tell you off the top of my head which buildings those were at this point. I mean, I could look back at my records. But that rent, at some point, the circuit court ruled because we had to get rid of escrow that was in our accounts. And at some point, that escrow was given back to the tenants either in full or at a 50% rate because they couldn't theoretically charge rent. But the money could have been used for the repairs. And I think Judge Kunke did something along those lines regarding that. We got rid of, ultimately, all cases where there was escrow and got those resolved. Additionally, with that, the cases that were here brought in the name of Arbor One were all dismissed. And so I was, when I found out, because they were filed in the name of Beal, and now they're filed in the name of Ram. Once I found out that it was Arbor One, I think it was Mr. Robinson that told me, he just blurted it out, and I stopped immediately because I didn't know that they could proceed. Okay. And also, counsel, I don't know what date, it was a Tuesday, I think, in April. Counsel, was it Bodman that was representing? They were representing Arbor One. And on the day that we got rid of the last of the cases that were before me, part of that large group, they made no mention, which I think they would have, that there were more Arbor One cases coming.
This is where the judge's suspicion sharpens into something very specific. If everyone involved in the broader Arbor One litigation knew these kinds of cases were still in the pipeline, why wasn't that disclosed when the earlier batch was being resolved? That's the question sitting underneath this entire exchange. Judge Simpson is not accusing anyone of bad faith outright, but he is absolutely highlighting a glaring procedural red flag. If Bodman or Arbor One's side was clearing out the last wave of related cases in front of him and nobody mentioned, by the way, there are additional Arbor-linked matters about to surface under a different name, then of course he's going to stop and ask whether these current cases are procedurally clean. And this is why he keeps pressing counsel to do more than just check with the prosecutor. He wants them talking to the attorneys from the Arbor One side too, because the problem may not be just, where are the circuit court cases? The problem may be whether RAM partners can proceed at all on claims tied to a litigation ecosystem that already produced dismissals, escrow issues, and rent disputes. That's a much bigger question than a single tenant owing a single balance.
I could confirm that with Bodman's attorney.
Okay, because I think that may be, certainly you can go to the prosecutor about where things are, but you may want to also go to them as to whether or not, because it may be, and RAM may or may not know that, it may be that they can't at this point proceed on these cases. But if you can, I mean, I don't mind hearing them, but because I like banging my head against the wall. But I don't mind hearing them, but it's just, I just want to make sure everybody's operating in the right way. And and I just want to make this clear. I don't doubt what those two are saying. I think, unbeknownst to a lot of people, these balances on some of these things got wiped. And not everybody knows, because that's what was happening on a number of different cases and units. All right, so what do you want me to do? Because I'm going to go back and rest for a minute.
Well, before you do that, Judge, perhaps we should adjourn.
Yes. How much time?
I've got to coordinate with at least 2 other offices, Judge.
You guys are all still in your units, right? Okay. Why don't you think if I kick them out to the 29th, just do the last Friday in the month and then figure out where we are? Does that work?
That should work, Judge.
All right. Then I'll adjourn these to May 29th, 2026, 3 p.m. in person. Okay?
Thank you, Judge.
You, young lady, you told me the last time you were on Zoom that you were all stressed out. You were giving me a bunch of stuff. All right, now listen. Just listen to me. All of this is confusing. I get it. It's confusing in some respects to me because there are all these moving pieces. Told me about some of the issues you had. Do not stress out about this, okay? You're not going anywhere. Nothing is going to happen until I say it's going to happen, and I haven't said so. So I do not want you worrying about anything. You hear me? You promise me? I don't care if you worry, because none of you worry, okay? You guys have a great weekend.
And this is where the hearing lands, not with a dramatic eviction ruling, not with a money judgment, but with Judge Simpson doing the most important thing available in a case, this tangled, hitting pause. The practical ruling here is an adjournment to May 29th, 2026 at 3 p.m. in person, so counsel can coordinate with the other offices, investigate the circuit court and Arbor One issues, and figure out whether these cases can even proceed in their current form. That's the headline. No tenant is being thrown out today. No final rent ruling is being entered today. The court is essentially saying, we are not moving forward until the legal foundation is clearer. And honestly, that's the only responsible outcome after what we just heard. You've got disputed balances, possible certificate of compliance issues, prior Arbor One litigation, escrow history, dismissed cases, a management company switch, and tenants saying they were told they didn't have to pay certain balances to avoid eviction. That is not a one-note non-payment case anymore. It's a layered procedural dispute where the judge's biggest job is making sure nobody gets steamrolled by bad records or incomplete information. What really stands out, though, is Simpson's closing tone with the tenants, especially the woman he tells not to stress. That wasn't fluff. It was the judge making clear that nothing is happening to them unless and until the court says so. In a hearing full of legal confusion, that may be the clearest and most reassuring statement anyone heard all day. So the takeaway is this. Judge Simpson did not rule on the underlying eviction merits today. Instead, he recognized the Arbor 1 Dar-Ram overlap, acknowledged that the balances may be contaminated by prior litigation and compliance disputes, and adjourned the cases so the parties can come back with answers instead of assumptions. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.